page 3. Continues to the same discussion. And page 4, in which I believe we had come to some resolution in relation to terms that would be used or amendments that would be made to omit the word stranger, as well as there was one other which we had discussed in relation to persons in good standing. But based on the discussions, well, is there any amendments? Can I get confirmation, please? Senator Shereen Golding Campbell, thank you. Senator Cavan Gale seconded. And matters arising from the minutes. I believe we had settled off on where we wanted to take standing orders 81, and I believe that there is a draft. There's a draft. Ms. Stewart? Ms. Stewart?
Good morning, Chair. Good morning, committee members. So, based on our deliberations last week, we would now be evaluating paragraph 2 of clause 81. Now, paragraph 2 states, if at any sitting of the Senate, any member moves that strangers withdraw, the President shall forthwith put the question that strangers do withdraw without permitting any debate or amendment. Now, the issue of contention that the members of the committee had was what grounds on which a member can move a motion that not a stranger, but a member of the public be withdrawn, particularly without debate or with any form of amendment to the motion moved. Now, based on research from other jurisdictions, particularly the UK, looking at the UK standing orders for the Houses of Commons, they have done away with the concept of strangers do withdraw. And based on the Modernization Select Committee, what has happened is a new provision has been implemented in the standing orders to explain or to give the rationale for the withdrawal. The issue is, in the UK, members of the public are asked to withdraw in order for the Houses of Commons to deliberate on matters that touch and concern national security or other critical issues. So what has happened, the approach undertaken, I will read their provision. The approach undertaken, instead of having strangers do withdraw, a member can now move a motion to say that the House sit in silent. So, sit in silent. Other jurisdictions sit in silent. Other jurisdictions, the member may move a motion to state that the House sit in camera in order to facilitate deliberations in private on national security or other issues of probably legal contention, high security issues, priority policy issues for the government. So based on that, I have a proposed amendment to our paragraph 2, and I will read. A member at any sitting of the Senate may, without notice at any time, for the purpose of enabling a matter to be debated in the absence of members of the public, move that the Senate sit in private, and the President shall forthwith put the question that the Senate sit in private without debate or amendment. We can deliberate. A member at any sitting of the Senate may, without notice, at any time, for the purpose of enabling a matter to be debated in the absence of members of the public move that the Senate sit in private, and the President shall forthwith put the question that the Senate sit in private without debate or amendment.
Sorry, I won't comment. Senator Gale first, and then Senator Morris.
You know, Chair, context and interpretation is always important. When you look at what was contained from 81, 2, 3, and 4, you would have arrived at an impression that the stranger then, now a member, would have conducted themselves in an inappropriate manner to be asked to leave the chamber. Especially when you speak about 3 that says the president may, whenever he thinks fit, order the withdrawal of strangers from any part of the chamber and its precincts, and may order the doors of the chambers to be closed. It gives the impression that that member would have been, there would have been a cause for an eviction of the member from the chamber. That's my interpretation. Now, based on what has been extended in terms of the other jurisdictions, it suggests that based on the nature of the discussions or the debate, it warrants the House or the Senate to speak in private on matters of interest and not what is contained here. So we now have 2 things to treat with, in my mind. One, in understanding and supporting that kind of perspective, and how do we treat with a particular situation based on what I would have arrived at, in my opinion, here. Yes.
It says, if at any sitting of the Senate, any member moves that strangers withdraw, meaning that strangers, members of the public, withdraw. So we're not talking about a member of the Senate withdrawn here.
No,
right?
I was very clear in my mind on that.
Very well.
Yes, Chair.
Senator Morris?
Yes, Mr. Chair. Based on the discussion, I think that the section and the matter that we're treating with here is really about strangers. Now, based on the research, it has revealed that there are other things that needs to be done. But in hearing the proposal read by the learned attorney, I am now forced to wonder if that amendment wouldn't be best placed in 26, which speaks to motions. I don't have my standing orders before me, but I'm just going off recollection. So you would have that amendment placed there, because that amendment would be used not only in the context of strangers, but in other situations as well, where, you know, a member could move a motion without notice. And then you would treat the specific amendment to 82, because 26 would be applicable with the amendment, and then you would treat the specific amendment to 81-2. You get what I'm saying, Mr. Chair? You have to look at 26.
26, I believe, speaks to where it's privileged motions.
Yeah. And privileged motion can be moved by any member.
But I think that may be a different section and with different intent from what is contemplated in 81. 26.
Save and accept, Mr. Chair, what I heard the legal counsel read is not just a matter that is germane to strangers. It can be used for other contexts as well. So that's why I thought that, placing it in 26 would be a better thing. And, members can always reference 26 and also 81.
All right, let us look at 81.2 is referring to a situation as I read it. The persons being referred to are persons who would have been invited within the chamber, which is here, right? So those are persons who are invited, and a matter gets to a point where during matters of confidence, confidential matters, sensitive matters that would have to be discussed without the person being present in the chamber.
Mm-hmm.
So that is what 81.2 is making reference to.
Right.
81.3 is a bit wider than that. It is wider. That no
orders the withdrawal.
Yes.
Yes, not only from in the chamber,
Right.
but within the precincts. So
Right.
that would take you into,
The car park.
well, yes.
Yeah. But
Yes.
listen to the
So if we have invited persons to attend here, I suppose, as I understood, Member Golden Campbell to be saying, that we should have something established as to a basis on which they are going to be asked to withdraw without any form of debate.
No, that wasn't the first thing.
What's that?
I'm saying that wasn't the first thing that Senator Golden Campbell pointed out,
I thought,
is the use of the negative term stranger. Because
yes,
she pointed
but-
out that how can you call individuals who own the parliament stranger in their own place?
and I think we got beyond that because
Right.
we have agreed that we're going to be changing that description. All right?
Mhm.
Now, the other issue was in what circumstance could one be asked? One who is invited here could be asked to withdraw. So in fact, you're withdrawing your invitation to a person attending within the chamber. Because a person, there's nobody who is facilitated within the chamber without an invitation.
No.
Right.
Chair, can I just ask a question for my own understanding and clarity? The 81.2 and the question of removal, I note that you are interpreting it to mean that it is removal from the chamber.
That is
Am I
that,
correct?
that is how I read it. That's my interpretation of it. I'm asking you.
I am not
You're
sure
not
that I think that is the interpretation revealed to me, because the 81.1 and 2, 81.1, strangers may be admitted to debates in the Senate under such rules as the President may from time to time make for that purpose. Is that interpretation equally that persons who are admitted to debates are admitted in the chamber to do what? To participate in debate or to observe debate?
But isn't that where do debates take place?
Well, it takes place in the chamber, but if it is to observe, then admission in the gallery in my mind, would fall underneath this. So I'm a little unclear about the intent of the provision. At 2, if at any sitting of the Senate any member moves that the strangers withdraw, the President shall forthwith put the question. And these are the same persons who have been admitted to the debate. So, please.
On the explanatory notes for the UK House of Commons standing orders, it was a combination. Persons who have been invited in chambers as well as members of the public in the gallery area.
Okay.
So that is how they interpreted.
Okay, so then my question then, I'm trying to understand the context in, well, here's my question. Have we ever, in the life of this parliament for 63 years, has a member ever moved that someone we withdraw from the chamber?
The answer that your father.
Huh?
Is one person could have given that answer is your father.
Unfortunately, don't have him to ask right now, but that I want to know, because you know we do adopt these provisions, and based on where we began in 1962, it's understandable, but I don't know, have we ever used it? And if we haven't used it, do we really know why it is here?
Yeah. But
to our previous sittings, one of the issues that senators raised, and you as well, Senator Golding Campbell, is the ambiguity that lurks in paragraph 2 in terms of, can a member just unilaterally move for no reason, without explanation, and then subsequent to no debate or amendment, any impromptu reason as to why members of the public need to be removed? So whether or not we have utilized or whether or not we intend to utilize this provision, some safeguard has to be placed in paragraph 2 to prevent any form of, where this situation arises, to eliminate any form of ambiguity. So it needs to be some form of context applied in paragraph 2 to say it would be on the grounds that the House probably sit in camera or in private to facilitate deliberations or debates or discussions or voting on sensitive matters.
Stuart, is precisely what my confusion is, because what you read as the guidance from the UK Parliament suggests that the issue is about having an in-camera sitting. But as I read 81, that is not the issue here. The issue here is the removal of a person. And so I don't see that as being removal for the purposes of an in-camera sitting on sensitive issues. This is the power to take someone who has come to the Senate out of the precincts, out of the Senate, whether by a motion by a member or by the order of the President.
The grounds, because that was the issue that was raised.
Right.
What grounds can a member of the public be removed?
Right. And so in your research, the grounds on which a person can be removed, was it based, was there any mention of conduct? Was it a conduct issue?
Yes, there are 2 grounds on which members of the public can be removed. The first, in paragraph 2, based on our jurisdiction, similar to the UK, is where a issue of national security or a sensitive matter needs to be discussed. That's the first one. And then the second instance is the issue of decorum.
Right.
In terms of all right, so it says strangers or members of the public shall preserve silence and must conduct themselves in a fit and proper manner during a sitting. But that is a different paragraph. We're not dealing with the issue of decorum as yet. what they tend to deal with first in the various jurisdictions is the issue of whether members of the public or visitors or strangers can be withdrawn and what grounds. So the legislations don't outline, national security, sensitive issues. They don't categorize it or outline what they are. They just say the House sit in camera or sit in private. They don't specify the grounds on which the members of the public may be removed outside of the concept or the issue of decorum.
And that is why I was saying that in light of
It's on, Flavia.
okay, in light of that generality, the particular section should be on the 26 because it is not speaking to the particular problem that we are dealing with here. You know, the Senate can be required to sit in private based on national security issues, etc., etc. And so the motion, such a motion, should be accommodated on the 26th. And so if you want to move a stranger from the parliament, 26 would apply, but also 81 too. Because you still would, the amendment would have already been done there. I suggest that you allow her to look at it, Mr. President, carefully. I think we are trespassing on the time for the Senate.
All right, before I yield to what you have just commented on, Senator Morris, may I hear from Senator Fraser-Vance, please?
Thank you, Chairman. And I will not comment on the proposal by Senator Professor Morris, but I looked at 81, and I want to recommend, particularly because time is upon us, that we take an overall view of 81, because it seems to me that the entire section needs to be rewritten. Yeah. As it is, we have agreed that members of the public can be admitted to the Senate. We now have to decide at what point or what are the reasons why they will be asked to withdraw, and who asked them to withdraw, and then what happens when they do not withdraw. I think it is with that in my mind is how we should look at redrafting 81. I'm sorry. I can't speak to Senator Morris's because I haven't gone through privilege at all. But it seems to me that the withdrawal or the motion to withdraw would be more than just national security issue. In fact, if anything at all, it should be more on decorum than anything else, and maybe a first or a second, just like with the actual senator, sorry, where if a senator is not behaving himself or herself, the president then speaks to the senator, and if he continues, then you name the senator, and if they continue, then you ask the marshal to gently escort the senator out of... so it seems to me it is within that parameter, I believe, that we need to look at Section 81, and perhaps we can look and see how we can redraft the entire section. Thank you, Chair.
Can you hear me? I agree with you. The entire sections need to be redrafted, but distinctions must be made. So paragraph 2 would deal with the issue of the national security sensitive matters, and I had suggested 2 sittings ago that a new paragraph 4 be included to deal with the issue, as Trinidad has done with the issue of decorum. So what Trinidad has done is include a new paragraph 4 to say strangers, but we are using members of the public, shall preserve silence and conduct themselves in a fit and proper manner during a sitting. And then it goes on to say that in the event of disorder, the president may order the withdrawal of members of the public from the chambers and its precincts, from the chambers and its precincts, and the president may require any member of the public who interrupts the proceeding or otherwise engages in misconduct to be removed or withdrawn from the sitting. So that's the approach, to include a new paragraph 4. But there are two grounds or two distinctions why members of the public can be asked to be withdrawn from the Senate. One, the issue of the deliberations of sensitive matters, which would be captured in paragraph 2, and then the new paragraph 4 to deal with the issue of decorum. That's how the various jurisdictions deal with it. So it captures the two grounds or the two reasons in one clause as to why members can be asked to be withdrawn. Yes, I will.
Praise a bit.
Just thanking council for that clarity and just supporting her by saying perhaps she could just redraft the entire section 81 so we can look at it our next meeting next week, hopefully.
Sorry.
Yeah.
And I'll just send. All right. So if do I get the sense from the members that what is being proposed in respect to the redraft to include sensitive issues, decorum, in the manner that was put forward by Ms. Stewart, is the way we should go, and we can just have a redraft to also include the change to the reference to strangers, and I believe there was one other term.
It also includes a new paragraph to include, for the purposes of this section or this clause, members of the public means.
Yes.
Yeah.
Yes. So, members, are we in agreement with that? All right. Send, all right, Madam Clerk. Ms. Lowe.
Good morning, everyone. Just to add to the recommendation for the amendment to number 81, that perhaps it could be extended to state the purpose of the reason why persons are in attendance, members of the public, which would be to attend and observe the sitting that is there, because members are not permitted to participate in debates in the while the debate is on the floor, but they can participate in committee meetings. So just for clarity, we could extend the definition to be clear on that.
All right, no objection to that. So Mr. You have captured the sentiment of the committee. You have captured it, and so you will do the full redraft and circulate it. And whilst just before we close off, because I would want for this particular standing order to be concluded on the next occasion, 5 speaks to, well, 5 is just a whole another kettle of fish, right? Because it speaks to the permission of any journal, which I believe speaks to the media, right? To attend sittings, and I say, under such rules as may from time to time for that purpose be established by the President. Do such rules exist?
It's a slight amendment that would be required for that paragraph based on what I've seen Trinidad has done. So there, paragraph 5 reads, the President may grant a general permission to the representatives of any journal or newspaper or medium of public information to attend the sittings of the Senate under such rules as he may make from time to time for that purpose. If such rules are contravened, such permission may be revoked. So they just expound beyond the concept of journal. They added or newspaper or medium of public information.
Well, I was just asking because, for the purpose of transparency, do those rules exist? Mm-hmm. So that everybody is aware as to what it is and what they can and cannot do, and you don't get into issues with that. Yes, ma'am.
Chair, given what we discussed in terms of removal of the word stranger and the definition now, the nomenclature now being members of the public, and the broad, the idea that a member of the public is entitled to attend, why would you need a clause to specify journals?
No, let me say this.
They come as members of the public under the same parameters. They have to observe the rules that the president sets from time to time. Why would you need to distinguish them from any other group?
Well, I think we have to probably think of how it is phrased, because their attendance does their attendance have to be here, or it can be on PBC by the
Well, the PBC is
wider way of
available.
publicizing the activities of the Senate,
No.
and not just in attendance. So when can you then say that although you are not present physically here, that a particular sitting or debate may be taken from PBC, right? Is something that probably is a little broader than what is contemplated.
Chair, I'm not sure if I'm understanding the point you're making.
You don't?
Can you just repeat it?
All right. Attendance.
Right. Of the
Gives the-
journalists.
Yes. Would give the impression that they are physically present here.
Right.
But attendance at the Senate has been given a broader definition for members who can attend by
Zoom. By Zoom.
on Zoom. Right? So I'm just saying it in that context. Because Senate sittings are broadcast on PBC,
Right.
and media houses don't actually have to come here in order to
To view the sittings, right.
benefit from
Right.
what is discussed here.
Right.
So that particular phrase and how it is and the rules that govern it and the rules when we may not broadcast through that medium is something that would have to be looked at. I'm saying in any redraft of 81.5. Right.
Chair, if I could just add to that I think the question of attendance, though, isn't necessarily captured by watching a broadcast, because the attendance does permit you to see things in the chamber that you don't necessarily see on a broadcast. But again, I'm just putting on the record that I don't think the entire phrase is required now that we're talking about members of the public and their right to be here.
All right. So
It's a removal of paragraph 5 in light of the new definition.
disseminate.
In that regard, I'd make a comment. Good morning, members. Pardon my manners. I'd make a comment to say that Standing Orders 81.5 appears to have a different purpose. It regards members of the media as being strangers, but we have to contemplate why they are here. Although they form part of members of the public, the reason as to why they are here is for a different purpose. They're not just here to observe, they're here to work. They're not working on behalf of the parliament, they're working on behalf of their respective media houses or organizations. And certainly, there must be some rule or guideline as to how they operate in this space. And I think that is what this standing order is intending to do. And although it is that we have advanced with technology, and yes, we have been ably assisted by PBC in broadcasting our sittings, you do have members of media houses that still come here and take photographs for especially special sittings. So we still need to maintain one, in my opinion, and my respectful submission, the Standing Order 81.5, and also implement rules and regulations as to what they can or cannot do whenever it is that they're in our precincts.
Well, I was inquiring whether there any rule exists, but when I turned to, you're not aware of. All right, so that is something that has to be contemplated in any event. But I think we have captured the essence of what it is that you are to do, Mr. Stewart, and we look forward to the redraft, and if it could be circulated before so that the consideration can be given to it and we can have a fruitful discussion on the next occasion. So I'll ask for the Standing Orders Committee motion for adjournment, please. So moved by Senator Morris and seconded by Senator Fraser-Vins. Standing Orders Committee stands adjourned.
90% and more that good for you. You feel zoom in, check the nutrition facts. You feel zoom in, check the nutrition facts. You feel zoom in, check the nutrition facts. Less sugar, less salt intake and less fat. You feel zoom in.
A message from the Ministry of Health and Wellness, Jamaica Moves, the Heart Foundation of Jamaica, the National Health Fund, and JAP.
Motorists, as Minister of Justice, I appeal to you, obey the road code, pay your ticket on time, and only go to court if the ticket is being contested. Close to 80% of matters coming to the parish courts are for traffic breaches. Let's work together to make our roads safe and ease the burden on our courts.
So who keeps our taxpayer money in check? Well, the PAC and PAAC help watch over the country's budget. And one might sound like it just have an extra A, but they're way different. Here's how. The PAAC and PAC are two committees that watch the money. The Public Accounts Committee reviews government projects after them close. They do a post-audit check to see what problems arose with the costs and call officials to explain decisions that cause budget mismanagement. And then they recommend corrective action, so the problem will happen from when, not happen again. But what about the money we are spending right now, the PAAC? That's how Public Administration and Appropriations Committee pretty much means your money will protect as it happen, we check. While projects go on, things are accurate. As government spend the nation's budget, PAAC reviews it. They examine proposals and summon officials to find problems before them don't use it. So the PAC and PAAC are two parliamentary committees that watch over the country's wallet to protect the budget and keep it in check. And you can get involved. Just visit jampja.org.
Me, I go show them my way of justice.
I'm abused.
I need legal advice. I don't deserve this.
The truth of the matter is, justice there for all of we. The Ministry of Justice has trained more than 5,600 persons in restorative justice practices. More than 200,000 victims have been supported by the victim services. Legal aid has reached thousands island-wide. Make we talk it out, not fight it out. Call 888 Justice today.
BGLC, the regulatory body. We regulate, you play without worry. We regulate, you play. BGLC, fair play when you play. For the fun of the game, you know when they are. BGLC, keep it fair for the player. You play the game and we are the rules setter. Keep everything fair so the game play better. The Betting, Gaming and Lotteries Commission. We ensure fairness, integrity and responsible gaming practices. Keep the game fair and fun for everyone. We regulate, you play.
Come July, your NHT home improvement loan will increase to $3.5 million for qualifying applicants. Your government is caring for you.
Cook it up and make we steam it. Fresh so me need it, tilapia a real fish. Cook it up and make we roast it. Farm fresh so me need it, tilapia a real fish. Grow smart at the best part. Food for thought so me have to eat smart. Easy catch, fully net. A tilapia so you don't know what's next. Cook it up and make we fry it. Fresh so me need it, tilapia a real fish. Bring home the best in freshwater fish. High content of vitamin B3, protein and potassium. Tilapia, simple, healthy, delicious.
Most major illnesses that affect Jamaicans are caused by unhealthy lifestyles. Over 50% of Jamaicans are overweight. 1 in 3 Jamaicans has high blood pressure. 1 in 8 Jamaicans has diabetes. 17% of Jamaicans have high cholesterol. A healthy lifestyle can reduce the risk of most of these diseases. Things like regular exercise and adequate rest can play an important role in maintaining good health. The other major consideration is eating healthy. The question is, how do you walk into a restaurant or fast food outlet and identify the healthier menu items? Better For You is an initiative to help Jamaicans to eat healthier. Restaurants and fast food outlets can voluntarily participate by identifying